Most people die carrying debt. In the U.S. alone, research suggests the majority of people who pass away leave behind unpaid balances. So here is the question nobody wants to ask. Does your family inherit your bills? This video breaks down exactly what happens to debt after death, who is legally responsible, and what protections exist for surviving family members. If this helps, subscribing takes 2 seconds. When you die, your debt does not simply disappear. It follows a legal process called probate. Your estate, everything you owned, becomes responsible for settling your outstanding balances. Think of your estate as a temporary holding account. It contains your savings, property, investments, and personal belongings. Creditors have the legal right to make claims against that estate. A court-appointed executor manages this process. They identify all debts, notify creditors, and use estate assets to pay them. Only after debts are settled can remaining assets pass to your heirs. If your estate has enough to cover everything, your family receives the remainder. But not every estate can cover every debt, and that is where things get complicated. Some estates are insolvent. That means the debts are larger than the total assets. In this situation, creditors get paid in a specific legal order. Secured debts, like mortgages, are typically prioritized. Unsecured debts, like credit cards, sit lower in the queue. Some creditors may receive nothing at all. But here is what most people get wrong. Family members generally do not inherit personal debt in the UK, US, or Australia. Your children are not automatically liable for your credit card bill. Your parents are not responsible for your student loans. Debt collectors sometimes pressure grieving families into paying anyway. They count on people not knowing their rights. However, there's one major exception that changes everything, and it catches thousands of families off guard every single year. In some U.S. states, a legal concept called filial responsibility exists. It can legally require adult children to contribute toward certain debts left behind by a parent, primarily relating to medical or care home costs. Enforcement varies widely by state and is rarely applied to general consumer debt such as credit cards. The real danger is joint debt. If you share a credit card or loan with someone, both parties are fully responsible. The death of one holder does not cancel the obligation. The surviving account holder owns the entire balance. This applies to joint mortgages, joint personal loans, and co-signed agreements. A co-signer is equally liable from day one. Many parents co-sign loans for their children without fully understanding this. If the primary borrower dies, the co-signer becomes solely responsible. The actionable step here is simple. Review every financial account you hold. Identify anything with a joint holder or co-signer. Speak with a licensed financial advisor about your specific situation. Understanding what you have signed is the first line of protection. What happens to secured debts like a house or car is a separate situation that deserves its own attention. Not all debt behaves the same way after death. A mortgage is tied to a physical asset. If the estate cannot continue payments, the lender can repossess the property. A surviving spouse living in that home may face serious consequences. Some lenders offer hardship provisions, but these are not guaranteed. Federal student loans in the United States are discharged upon death. The loan is canceled entirely when proof of death is provided. Private student loans are different. Many, though not all, private lenders require repayment from the estate or a co-signer, so it is worth checking the specific terms of any private loan agreement. In the UK, student loan debt from government programs is written off at death, though the exact terms differ slightly depending on whether the loan is Plan 1, Plan 2, or Plan 5. So borrowers with less common loan types should verify their specific conditions. Australia operates similarly with its government loan system. Life insurance can be a powerful tool here. Experts widely recommend that policy payouts go directly to named beneficiaries. This means the payout typically bypasses the estate entirely. Creditors generally cannot touch a life insurance payout made to a named living beneficiary. That distinction between assets inside an estate and assets outside it is one of the most valuable things you can understand about personal finance and estate planning. Your debt does not automatically transfer to your family, but joint accounts, co-signed loans, and insolvent estates create real risk for the people you love. The best protection is understanding the rules now, while you still have time to act. Drop a comment below. Did the filial responsibility law surprise you? Or was it the student loan rules? Subscribe for the next video on what happens to your assets when you die without a will. The answer is more alarming than most people expect.